It's Chedington Court.
Yes, Mr. Doctor.
My lords, my lady, I appear with Mr. Day and Miss Scott for the appellant Chedington. My learned friends, Mr. Curl and Mr. Colclough, appear for the respondents, the Brakes. My learned friend, Miss Alsop, sitting on Miss Scott's left, appears on a watching brief for Mr. Swift, who was the trustee in bankruptcy at the relevant time, and who adopts a neutral position on the application and the appeal. The current trustees in bankruptcy are not represented, but again take a neutral position on the application and the appeal. The appeal raises an important question. In what circumstances do bankrupts or former bankrupts have standing to challenge the acts, omissions, or decisions of their trustee in bankruptcy under Section 303(1) of the Insolvency Act 1986? In Chedington's submission, the answer to that question is that bankrupts or former bankrupts only have standing when they are seeking relief that advances their interests as bankrupts within the bankruptcy process. They do not have standing when they are advancing an interest that does not arise by virtue of their position as the bankrupt or former bankrupt. My learned friend says at paragraph 13 of his written case that drawing a principled delineation between matters internal and external to the bankruptcy is not straightforward. We disagree. My learned friend accepts at paragraph 1.3 of his written case that the relief sought must relate to an act, omission, or decision of the trustee done in his capacity as trustee. Chedington's case is simply that the right or interest allegedly interfered with by the trustee must also be held by the bankrupt in his capacity as the bankrupt and not in some other capacity. In other words, the question of capacity must be asked not just of the trustee, but also of the bankrupt. That is what enables the court to determine whether the matter is within or internal to the bankruptcy. In my oral submissions, I will develop three main points in support of that answer. First, the approach taken by the court below and the respondents in their written case involves a misapplication of the standing principle articulated by Lord Millett in Deloitte to the facts of this case. What the Brakes have done here is to advance an interest in West Axnolla Cottage, which has nothing to do with their position as former bankrupts. It follows that they do not have a legitimate interest for the purposes of Section 303(1). Second, Chedington's case on this appeal is supported by the legislative history and previous case law, including Dodwell, on the standing of bankrupts to interfere in their insolvencies. The decision of the court below went beyond the previous cases. It was the first time that bankrupts had been permitted to assert standing to pursue an interest which had nothing to do with their status as bankrupts. Third, the answer proposed by Chedington on this appeal brings the law on bankrupt standing back into line with the law on the standing of creditors and also with Commonwealth authority. In particular, cases such as Mohammed and Morris and Fairfield have consistently held that creditors do not have standing where they pursue interests which they hold in a capacity that is external or adverse to the insolvency. We say that the same approach should be taken to bankrupts. Before developing those three submissions, we need to identify what the breaks rely upon as constituting their legitimate interest in the relief sought by their application. The relief in this case concerns both West Axnoller Cottage and also what we call in the agreed facts the adjacent land. Can I ask you to turn up the originating application notice, which is in the core bundle at tab 7, page 153.
That looks like the second page of it.
It is, sorry. The first page is at 152.
I'm really just seeking to check we're not one page apart.
No, that's quite right, my lord. It's the second page I want to take you to. And at the top of the page, the property with title number ending 2107 is referred to as Cottage 1.
Sorry, I'm just sorry, which?
Sorry, my lord, page 153 in the core bundle.
Yeah.
Top of the page, it says the application concerns, then in subparagraph 1, Cottage 1 is the cottage itself.
Sorry, computer seems to
Do you want us to rise or come?
No, come on. What are we looking at? Can you just...
Page 1.
Page 153, my lady.
Yes, carry on with the subject.
You will then see a separate reference to a different parcel of land called the access land, or Cottage 2. That's what the agreed facts describes as the adjacent land. The standing challenge, now on appeal to this court, concerned the relief at prayers A in the prayer at the bottom half of the page, A to C and F. No standing point was taken on the rest of the relief. And the relief at prayers A, B, and F concerned the disposition of both the cottage and also the adjacent land to Chedington. Prayer C only concerned the cottage and not the adjacent land, as the license was only in respect of the cottage. It is also now entirely academic for reasons I will come on to. The position with the adjacent land is more straightforward, so I will take it first. This land was registered in the name of Mrs. Brake, the first respondent, and she held it in her personal capacity. It vested in her trustee following her bankruptcy in 2015. Her trustee then sold it to Chedington in December 2018. I need to correct one point in the agreed facts. Paragraph 13 refers to Dr. Guy buying the adjacent land. In fact, it was Chedington, not Dr. Guy, personally, that bought this land. Mrs. Brake contended that the adjacent land revested in her under Section 283A of the 1986 Act. She had standing to seek that relief because it concerned an alleged interest she held by virtue of being the bankrupt. That application was tried and dismissed in 2020, and permission to appeal was refused. The references are at the agreed facts, paragraph 28. This appeal is about whether Mrs. Brake also has standing to pursue the relief at A, B, and F in respect of the trustee's disposition of the adjacent land. The position of the cottage is a little more complicated. The cottage was partnership property. It was registered in the names of 3 partners, Mr. and Mrs. Brake and Mrs. Bream, who held it on trust for the partnership. The beneficial interest in the cottage fell into the liquidation estate of the partnership. The Brakes brought proceedings against Mrs. Bream in 2012 in respect of the cottage, which included a proprietary estoppel claim. That's paragraph 7 of the agreed facts. That estoppel claim has never been determined, but it is common ground that it constituted a mere equity which fell into the bankruptcy estates. The transactions as to the cottage are set out at paragraph 17 of the agreed facts. In outline, the liquidators sold their interest in the cottage to the trustee in bankruptcy. The trustee in bankruptcy then entered into a conditional sale agreement with Chedington to sell the combined liquidation and bankruptcy interests to Chedington. Pending completion of that sale, the registered owners, including Mr. and Mrs. Brake, hold the cottage on bare trust for the trustee in bankruptcy. And as with the adjacent land, the Brakes contended that the equity in the cottage revested in them under section 283A. Again, they had standing to seek that relief because they were interested in it in their capacities as the bankrupts. That application was also tried and dismissed in 2020, and permission to appeal was refused. That left the relief at prayers A, B, C, and F. The Brakes standing to seek this relief in respect of the disposition of the cottage is the focus of this appeal. At paragraph 11 of his written case, my learned friend says his client's interest in challenging the disposition of both the adjacent land and the cottage arises from their possessory right into the cottage. In other words, their right arising from their adverse possession of the cottage. That was not the basis on which his client sought to justify their standing on their pleaded case or at first instance. The reference of the pleaded case is tab 7 of the core bundle at page 155. We don't need to go there, but that's the reference. And the reference to the judge's judgment at first instance is in the key volume at tab 7. In the Court of Appeal, the Brakes argument focused on alleged fraud and bad faith and the effect of the license. However, in the course of argument in the Court of Appeal, the Brakes conceded that they were alleging no more than fraud on the power in the sense of improper purpose. You will see that if we go to the Court of Appeal judgment, which is in the key documents bundle at tab 5, page 142, where you'll find paragraph 86. Paragraph 86 at the top of the page.
Did you say 145?
Sorry, tab 5, page 142.
Thank you.
So the fraud point fell away. As for the licence, its effect is dealt with in the preceding paragraph, paragraph 85, where you will see 4 lines down, the sentence beginning, at the very least, their interests were substantially affected by the grant of the licence and consequences which flowed from it. Even the licence has now fallen away as a result of the most recent Court of Appeal decision in the litigation between the parties. For your reference, the judgment is at the supplemental bundle, tab 6, pages 141 to 169. In summary, the Court of Appeal's decision was given in the so-called eviction proceedings, which are Part 7 proceedings where the Brakes pursue a claim in the general law based on their possessory interest in the cottage. Lord Justice Lewison gives the leading judgment and concludes that the licence granted by Mr. Swift to Chedington in respect of the cottage did not override or disturb the Brakes' existing possessory interest in the cottage arising from their adverse possession of that property. Apart from declaratory relief, the question of what, if any, other relief the Brakes are entitled to, such as any possession order, has not yet been determined. That is because the Brakes have accepted that any interest they held in the cottage is subject to the bare trust under which the current trustee in bankruptcy is the beneficiary. It is worth looking at the Court of Appeal's order, which was made some 3 weeks ago on the 10th of October, and that is in the supplemental bundle at tab 5. Page 139. You will see the relevant declaration. Can I ask you to note the registered title number of the cottage ending 2107? The declaration is limited to the cottage and does not apply to the adjacent land. You will also see the directions at paragraphs 3 to 8 for further submissions, with provision for the current trustees in bankruptcy to intervene in light of the Brakes' concession in the Court of Appeal that they have no beneficial interest of any sort in the cottage as against the trustee in bankruptcy. The further judgment, possibly following another hearing, will not be until the new year, and we can of course then update this court if that would be of assistance.
That's coming back to the Court of Appeal.
It is.
Constituting themselves for that purpose.
It is, and it's for the court. If the parties request a hearing, it's for the Court of Appeal to decide whether or not to permit a hearing or whether to deal with it on paper. For present purposes, there are 4 important points to note. The first is that the only legitimate interest identified by my learned friend in his skeleton argument is the Brakes' possessory right in the cottage. The Brakes have accepted that this possessory right is not something in which they have a beneficial interest. They accepted in the Court of Appeal that the beneficial interest in the possessory right to the cottage vests solely in the trustee in bankruptcy. Yet on this application, they still seek to set up that same possessory interest against the trustee in bankruptcy. My learned friend has not yet addressed that inconsistency. Even if he is right on the law, we say that the Brakes' recognition that their possessory interest in the cottage is subject to the trustee's rights as beneficiary makes it impossible for them to say that the same possessory interest gives them standing to challenge the trustee's dealings with the cottage. I'll see how my learned friend explains how he squares the circle and replies necessary. Second, if we go back to the originating application notice, that's in the core tab 7153, prayer C is now academic because the Court of Appeal has disposed of this issue under the general law in the Part 7 eviction proceedings. The licence has been found to have no effect as against the Breaks possessory right. Given the licence was the only thing said to interfere with the Breaks possessory rights, and that has now fallen away, it's entirely unclear on the Breaks case what legitimate interest they have left in the relief at prayers A, B, and F. Third, as we saw in the Court of Appeal's declaration a moment ago, the Breaks have only ever asserted and established a right by adverse possession to the cottage itself. My learned friend's written case identifies no legitimate interest in relief concerning the adjacent land at all, despite that being one of the two contracts which the Breaks seek to set aside. The fourth and final point is a broader one. The Breaks possessory interest in the cottage as squatters confers limited rights and affords limited remedies in the general law. There is nothing in the possessory right of a squatter to land in the general law that gives them a reasonable expectation to prevent the sale of the registered freehold, nor to demand a new sales process for that freehold title under the direction of the court, and still less to make those demands against the person for whom they hold the registered title on trust. The relief sought at A, B, and F therefore goes far beyond any remedy which the Breaks could legitimately expect to follow from their possessory interest in the cottage in the general law. And the question is this: should the Breaks be allowed to pursue an application that seeks to invoke remedies available within the insolvency jurisdiction that go far beyond what would be available to them in the general law? The answer we submit is no. The Breaks should not be entitled to remedies well beyond what the general law would give them in respect of their possessory interest in the cottage. And that answer is corroborated by the law on standing, to which I now turn. My first main submission concerns the proper application of the Deloitte test. Deloitte is in Primary Authorities, tab 8. And if I could ask you to go to page 90. Can I ask you to read from the sentence between C and D beginning, "It is therefore incumbent," third line above D, down to the sentence ending "relief sought" at letter E.
Just give me the page again.
At page 90, my lord.
So where did you start?
Starting 3 lines above D with the sentence, "It is therefore incumbent on the court."
Yeah.
as Lord Millett makes clear in this passage, the breaks need to show a legitimate interest in the relief sought. Only then will they be considered a proper person to make the application. Legitimacy in the context of an insolvency application requires the court to consider whether the applicant falls within the class who could properly benefit from the relief if granted. Deloitte itself was an application by the company's former auditor for the removal of liquidators in the context of an insolvent liquidation. And at 87, I could just ask you to go back to 87, between C and E, we see that the basis of the auditor's removal application was an allegation that the liquidators had a conflict of interest because their firm was also implicated in the audit issues. The Privy Council did not consider the merits. It proceeded on the assumption that the conflict of interest existed. We see that from the paragraph G on that page. Then if we could go back to page 90 to the paragraph beginning between G and H, the company is insolvent. We see there that Lord Millett says the only persons who could have any legitimate interest in removing the liquidators are the creditors. That was because the company was insolvent. The applicant was not a creditor, but rather as auditor, a stranger to the liquidation. It followed the application. The applicant was not a proper person to make the application. Lord Millett's analysis was obviously focused on the interests internal to or within the liquidation. He in effect asked what interest the auditor had within the liquidation, and the answer was none. This is confirmed by subsequent cases, and by way of example, can I ask you to go to the supplemental authorities bundle at tab 45, where you will find the judgment of Chief ICC Judge Briggs in Re Sturgeon, and the passage I want to take you to is at page 355, which is headed the standing of Mr. Carter to make the application to terminate. Could I ask you to read paragraph 48 and then paragraph 49, running to the end of the first sentence at the top of page 356. It's the sentence that ends on the top line of 356.
do you want us to stop?
The top line of the following page, page 356.
Of 356.
Of 356, ending in the insolvent estate. As my learned friend correctly put it in his submissions in that case, in order to have standing to make an application within an insolvency process, the applicant must have a recognizable economic interest in the outcome of that insolvency process. Put another way, they must have a relevant interest that is internal to or within the insolvency. We submit that the same analysis should be applied to the present case. The Brakes are seeking to set aside the transactions between Mr. Swift, Moore Stevens and Chedington. That for your reference, the relevant documents are at core volume 7, pages 270, 281 and 288. Followed by a resale under direction of the court. The Brakes are not able to point to any recognizable economic interest they have in the bankruptcy to which the relief they seek relates. It is common ground that a resale will not render their bankruptcies solvent. There's no prospect of a surplus or annulment. The Brakes are not creditors, and no creditors support the application. Indeed, the principal creditor in the bankruptcies, Mrs. Breen, supports the transactions that are now being challenged. It follows that, as in Deloitte, the relief in question was rightly struck out at first instance. The Brakes are not proper persons because they are not part of any class within the insolvency who could legitimately be interested in the relevant relief. The Brakes' difficulty in satisfying the Deloitte test is further demonstrated if we look at the case of Locke against Stanley, which is in primary authorities at tab 12. Page 124. This was a decision on standing under section 168(5), the equivalent provision in liquidation. Like this case, it concerned a challenge to the sale of assets out of the estate. The only difference is that in Locke, the relevant asset was a cause of action rather than real estate. That's obviously a distinction without a difference. Lord Justice Mayles picks up the question of standing at paragraph 23 on page 130. He cites various cases, including Deloitte, at paragraph 28 on page 131. He then refers to the decision of the court below, in this case, at paragraphs 34 and 35 on pages 133 and 134. Could I ask you to read those paragraphs?
Sorry, which paragraphs?
Paragraphs 34 and 35. There's one slight error that was made by His Lordship in his summary. In the first line of paragraph 34, he refers to the applicants being unsecured creditors of the partnership. In fact, the applicants were the Brakes and they were not creditors. But
Weren't there some unsecured creditors who joined in the proceeding?
you're quite right, my lady, there were. But
Well, this seems to be dealing with a different aspect of that Court of Appeal decision from the one that...
you're quite right, my lady. It's dealing with the liquidation application, which was dismissed, but appeal. But I particularly want to ask you to note what Lord Justice Mayles says at paragraph 35 on page 134 was the effect of the relief sought by the Brakes applications. And His Lordship then concludes at paragraph 36, and can I ask you to read that?
The result have been the same, even if they had bid more, insofar as they're claiming as bankrupts, not as unsecured creditors.
If there was no prospect of a surplus or annulment, then that is right, my lady. If I could ask you to read paragraph 36. If I could then ask you to read paragraph 38 on page 135. In this case, by challenging the sale to Chedington, the Brakes do not claim to be acting in the interests of creditors, and even if they did claim to be acting to benefit creditors, they would clearly lack standing since they are not creditors themselves. Nor are the Brakes advancing their interests as bankrupts. On their own case, the Brakes' only interest in the cottage is their present possessory right to the property arising from their post-bankruptcy adverse possession. That has nothing to do with their position as bankrupts in the bankruptcy. Further, they cannot be asserting both interests simultaneously in a dual capacity, for the reasons given in my learned friend's skeleton argument in Locke and Stanley, as approved by Lord Justice Mayles at paragraph 38.
I think you would say that even if they were creditors of each other's bankruptcy, they wouldn't have standing because their interests are hostile to the body of creditors generally.
I would. The class interests of the Brakes as bankrupts would be to realise the cottage for as much money as possible to increase any prospect of a surplus. On the other hand, the interests of the Brakes as adverse possessors is for the cottage not to be sold at all, or only sold to them, preferably for as little as possible. In fact, it is clear that the Brakes' real interest in this relief comes from outside the bankruptcies rather than as the bankrupts. And as Lord Justice Mayles noted in paragraph 35 of his judgment, the effect of the Brakes applications would be to result in a lesser recovery for the estate. You will see that if we go to the core volume, tab 7, and if you could go to page 190. Page 190 is the prayer in the has at paragraph 3 is the prayer in the liquidation application. The Brakes' primary case was that the cottage should be resold to them at their original bid price of $476,000, which was less than the $500,000 accepted by the liquidators from Chedington. It's not clear whether the Brakes maintain that position now for the purposes of the bankruptcy application. If they do, that is plainly not advancing the interests of the estate or any interest they have in the estate. Further, as we pointed out in our written case, that's paragraphs 64 to 66 of our written case, the Brakes don't even have the funds to buy the cottage themselves anymore, nor have they identified any third party who might buy the cottage on better terms than Chedington. My learned friend has not engaged with that point in his written case, but it's obviously a relevant consideration for standing.
Just a little, I'm quite sure I'm following this. Paragraph 3 that you've directed us to is a direction that was sought against the liquidators.
That's right.
Isn't that right?
That's right.
And failed.
That's right.
So, I mean, it's gone. It's no longer, I mean, it can't be pursued anymore.
Well, that is absolutely right.
There's nothing that could happen in the bankruptcy which would affect it anyway, is there?
Well, what they're seeking in the prayer for relief in the bankruptcy is to set aside the transactions in relation to the cottage.
But they presuppose that the liquidators had sold the beneficial interest
To the trustee.
No, to the trustee, yes.
At the time,
I see.
at the time this pleading was drafted, obviously they were challenging.
Well, yes, I was just wondering what place this has now. That was my point, really.
Well, my
Paragraph
lord,
3.
we simply refer to it to show what the Brakes' primary case was in relation.
I follow. Well, but not now.
Well, we don't know now. That's
We do, because we've got the bankruptcy application, which has paragraph 4, but not paragraph 3.
my lord. Yes,
I mean, the equivalent of paragraph 4,
The equivalent.
without the alternatively.
Sorry. I'm lost. Sorry. I'm a little lost.
yes. My lord Legate is right. In paragraph 6.
6.
On page 191, in the alternative to 4 and 5 above, they're seeking a sale of Mr. Swift's interest in the cottage and the adjacent land under the direction of the court. Now, what direction are they seeking from the court? That it be at the original bid price, or what? We don't know.
I welcome your submissions at some stage, Mr. Sutcliffe, on what strikes me as a timing problem. Standing issues generally arise at a very early stage in the prosecution of an application of this kind. Indeed, if they didn't, there wouldn't be much point in making a fuss about them, because they're designed to winnow out cases which, even if they might have some arguability on the underlying merits, ought not to trouble the court, or indeed the office holder or other creditors. An enormous amount of judicial water has flowed under the bridge since this application was made and since the standing point was first taken. So that, for example, we've got a really learned Court of Appeal decision in the eviction proceedings about the precise nature and effect of the break's possessory rights in relation to the cottage, which wasn't available when this application was originally made and the standing question was resolved. We're hearing an appeal against the Court of Appeal's reversal of a negative standing decision. I fully appreciate that if we were to set aside the Court of Appeal's decision without necessarily reinstating the first instances, we might have to consider the matter as it stands now. But it seems that as matters develop, the sort of one's perception of what the underlying rights are is capable of changing over time. What times do you say we should be focusing on?
Well, my lord, my primary submission is that you should look at it now, in the events which have happened. But my alternative submission is that the learned judge, Judge Matthews, at first instance, was correct in the view that he formed then, and standing, whether it's taken on the facts as they appeared to the judge at first instance or as they appear now, it is not something that the breaks can show they have. Finally, on the Deloitte principle, at paragraphs 86 to 89 of his written case, my learned friend relies on the decision of the Privy Council in PricewaterhouseCoopers against Sard, which is in the primary authorities bundle at tab 16. There are, page 208. It starts at 200. There are three reasons why we say PwC against Sard does not assist. First, this appeal is about standing to make applications within ongoing insolvency proceedings. PwC was not such a case. Rather, PwC was about who can be heard in response to a winding up petition at the outset of proceedings, and therefore who can at a later time make an application to set it aside and end the insolvency proceedings. The Deloitte test does not apply in that context. Different considerations apply as to who can respond to a winding up petition. No doubt for that reason, Deloitte was not even cited to the Privy Council in PwC, as you will see from the law report at page 201. Second, the central issue in PwC was about the court's jurisdiction to make a winding up order at all. The Privy Council's reasoning suggests that standing to raise specific jurisdictional objections may be different to standing in insolvency applications more generally. That is because the court simply did not have the power to act as it did. In contrast, the breaks application in this case has nothing to do with the court's jurisdiction. There's no dispute about the court's jurisdiction under section 303(1), Rather, the question on this appeal is whether the brakes are the proper persons to invoke that jurisdiction. Third, the Privy Council in PwC emphasised the unusual fact, that's in paragraph 31 on page 208, that the applicant challenging the winding up order was only a stranger to the liquidation in a technical sense. If I could ask you to go to page 208, and you'll see the reference to the most technical sense in the last line of paragraph 31, but if I could ask you to read paragraph 33. A similar substance over form approach, in this case, leads to the opposite conclusion. It is clear as a matter of substance that the break's possessory interests are not held in their capacity as bankrupts. They are outside interests which should not be pursued within the insolvency jurisdiction. I now move to my second main submission, which concerns the law that addresses the question of a bankrupt standing to make applications within bankruptcy. Despite the number of authorities cited in the parties' written cases, there are in fact only 2 cases since the start of the 20th century which directly address the question of a bankrupt standing under section 3031 or its predecessor provisions. Those are Dodwell and Engel and Perry. I should say only 2 cases in England and Wales. Both cases base their analysis on the interests which the bankrupt has within the bankruptcy in the relief sought. Before turning to those cases, it's helpful to provide some context. The legislative origin of section 3031 was section 20 of the Bankruptcy Act 1869. But the position at common law before the 1869 Act is instructive. Can I ask you to go to the Supplemental Authorities Bundle, tab 69, where you will find extracts from...
We don't have tab numbers, by the way.
Oh, I'm sorry.
So they're
Thank you, Mo.
superfluous. It's only the page numbers.
I'm grateful. Page 595. Page 595 is the start of, and you will see there are extracts from Griffith and Holmes' Law and Practice of Bankruptcy, published in 1867, so 2 years before the 1869 Act. This book contains more analysis of a bankrupt standing than any later commentary, and it shows a well-developed jurisprudence at common law on when bankrupts had standing within their own bankruptcies. If you go to page 644, which is the last page in this section, 644, you will see the margin note from the authors in italics. No, it's not in italics. Bankrupt may petition in court of bankruptcy in all matters where he has a direct interest. And next to the margin note, you'll see a sentence beginning, in the court of bankruptcy, he may petition. And the authors go on to note that the bankrupt has standing to seek to annul his bankruptcy, and concerning issues of surrender, allowance, and surplus. The unifying theme of all these interests is that they are interests which the bankrupt had within the bankruptcy by virtue.
Direct interests is the adjective that they use.
Yes.
All matters relating to his bankruptcy in which he has a direct interest, as for instance, and then the ones that you...
Yes, yes, my lady.
But does it give any examples of things he can't do?
No, no. And my lady, I think it is worth showing the court what the authors say about each of these categories. If I can take you to annulment first, which is dealt with at page 597. Near the top of the page, there's a paragraph, a heading, who may apply to annul. And if I could ask you to read from there down to the end of the sentence, finishing with the footnote K, which is about 10 lines down. Annulment plainly fits the Deloitte test. The relief is directly relevant to the bankrupt's interest in the end or outcome of the insolvency process. And that's an interest which the bankrupt has in the estate by virtue of being the bankrupt, and so is internal to the bankruptcy. Now, surrender to court is no longer a feature of the modern law, but it is dealt with at page 610. Failure to surrender was a criminal offence, and the bankrupt had standing to extend the time for surrender. We see that in the middle of page 611. And again, this fits with the Deloitte test. The relief goes directly to the bankrupt's rights and obligations within the bankruptcy. A bankrupt's allowance from the bankruptcy estate is also not a feature of the modern law. Again, this was an entitlement within or internal to the bankruptcy. Can I ask you to go to page 639 and to read about halfway down the paragraph beginning, it was held to that a bankrupt could call upon the assignees to, over the page, the paragraph ending with footnote S on page 640, which is about 8 lines down from the top of the page. This is again consistent with Deloitte. The allowance is a right which the bankrupt has by virtue of being the bankrupt. It's a right within the bankruptcy.
What was it?
The allowance.
Yes.
I'm afraid, my lord, I don't know that I can answer that question. Oh, I'm told by Mr. Day it was 5%. And you see that from page 638.
Thank you.
Yes, 5% in the penultimate paragraph on 638. But it wasn't as of right.
I see.
Then finally, on surplus, this permitted bankrupts to hold office holders to account for their conduct more generally. If I could ask you to go to 642, and towards the bottom of the page, if you could read from the paragraph beginning, if a certificated bankrupt, that shows merely a probability of a surplus, to the end of the paragraph at the top of the next page. It ends on the second line of the next page. The reference to a surplus giving the bankrupt an interest must be referring to an interest internal to the bankruptcy. In other words, it's a right which the bankrupt has in his capacity as bankrupt against the trustee in his capacity as trustee. So that's the position before the enactment of the Bankruptcy Act in 1869. There is no material to suggest that Section 20 of the 1869 Act was intended to widen the circumstances in which bankrupts could make applications in their bankruptcies. On the contrary, as we explain at paragraph 10 of Appendix 1 to our written case, there's evidence to suggest that the intention was simply to codify the common law. Section 20 you will find in the primary authorities bundle at page 10. And once you are there, you will see that the relevant part, the third paragraph of Section 20 contains what is now Section 3031. And that part of Section 20 became Section 90 of the 1883 Act, and for your note, that's at page 13 of this bundle, and then Section 80 of the 1914 Act, and again, for your note, that's at page 16 of the bundle. And it is under the 1914 Act that Dodwell is decided. We address Dodwell at paragraphs 27 to 32 of our written case. My learned friend addresses it at paragraphs 29 to 33 and 79 to 80 of his written case. You will find it in the primary authorities bundle at page 75. The key passage is at page 79. Can I ask you to read from the paragraph that starts in the middle of the page with this motion pruned of its more extravagant claims and stop at about 12 lines down, clearly concerned to increase, if he can, its amount. Dodwell did not create a universal surplus rule. Mr. Justice Harman was not seeking to legislate for every possible case. We see from the fourth line of this passage that he was considering the extent to which, if any, a bankrupt was entitled to, and I quote, call the trustee to account for his management and disposition of the estate. And he concludes in that context that the bankrupt must show there is or will or might be a surplus. That is consistent with the 19th century authorities summarised in Griffith and Holmes, and it is consistent with Chedington's case on this appeal. Our case is that the breaks application is properly characterised as a disposition application like Dodwell. The sole focus of the disputed relief is to stop or reverse the disposition of bankruptcy assets to Chedington. It's only by pointing to a potential for a surplus that the breaks could demonstrate any interest within the bankruptcy in the disposition of the cottage. It follows that without the prospect of a surplus, the breaks have no legitimate interest in this relief. My learned friend says in his written case, paragraph 32, that Dodwell is not applicable to this case because this case is not a case about day-to-day conduct. That is simply, with respect, wrong. Dodwell was not limited to day-to-day conduct. The thrust of the former bankrupt's challenge in Dodwell was to the trustee's disposition of bankruptcy assets to a third party. The bankrupt wanted to reverse that disposition so that the assets could instead be transferred to him. That was why the rule articulated by Mr. Justice Harman, in the passage to which I've taken you, is said to apply not only to the administration of bankruptcy assets, but also to their disposition. Dodwell was an asset disposition case, just as this case is an asset disposition case. My learned friend also says that Dodwell would now be a Section 304 case. Again, with respect, that submission is misconceived. In Dodwell, the bankrupt wanted to stop the sale of a housing portfolio to third parties, exclude the revenue as a creditor, and thereby generate a surplus which would enable the housing portfolio to revest instead in the bankrupt. The bankrupt in Dodwell was not interested in the trustee accounting to the estate for any misapplication or retention of bankruptcy assets. The central thrust of the application was to recover the housing portfolio from the bankruptcy estate. The bankrupt would not have made a Section 304 application even had it been open to him. It follows on that analysis that the break's failure to identify any possibility of a surplus arising from a resale of the cottage is fatal to their case on standing. To be clear, it is not Chedington's case that a surplus is a universal requirement. A surplus is not necessarily required where the challenge does not concern disposition of bankruptcy property. The requirement for a surplus is simply how the legitimate interest test works in the context of disposition cases. May I now turn to the Cork report, which is in the primary authorities bundle at page 287 is where it starts. And if I could ask you to read paragraph 779 on page 288, which runs over to the top of page 289. There are three errors in this passage. First, the committee traces the provision to the 1883 Act, whereas it first appeared in the 1869 Act. Second, the committee appears not to have taken into account the case law before the 1869 Act, to which I have referred you. And third, the reference on page 289 to what still seems to be the law, which must be a reference to Dodwell, gives the ratio of Dodwell too wide a scope. The purpose of the motion in Dodwell was to reverse the proposed disposition of bankruptcy assets. In that context, it makes sense to require the bankrupt to show a potential surplus, as otherwise they have no interest in relief in their capacity as bankrupt. Other forms of maladministration may not require a surplus as a prerequisite. In non-disposition cases, a bankrupt may be able to show an interest in their capacity as bankrupt in some other way. But of course, this is not a non-disposition case. The relevant relief is entirely about the disposition of the cottage. Although its analysis contained errors, the Cork report is nonetheless relevant because it provides the relevant context against which the 1986 Act was passed. Given what the Cork report said about the centrality of a surplus rule, it is striking that no step was taken by Parliament to remove a surplus requirement for challenges by bankrupts to dispositions from the estate under Section 303. Instead, the only disapplication of the surplus rule comes in Section 304. In other words, the parliamentary draftsman turned his mind to the question of surplus as a standing requirement for bankrupts for this very part of the Insolvency Act, but only legislated against it in Section 304. Paragraph 74 of his written case, my learned friend says that this means nothing because Rule 1835, Subrule 4 of the Insolvency Rules 2016 expressly provides that a bankrupt can only challenge trustee remuneration if there's likely to be a surplus. With respect, that submission is misconceived. The provision of the 2016 rules to which he refers was previously Rule 6.1422A of the 1986 rules and was introduced by amendment in 2010 by the Insolvency Rules Committee. That much later amendment of the secondary legislation says nothing about Parliament's intention in 1985 when the Insolvency Act was being drafted following the Cork report. And if you need an authority for that proposition, it's in Section 24, Spot 18 of Bennion on statutory interpretation. We can provide copies if that would assist. That deals with Dodwell. The other key case is Engel and Perry, which is at page 103 of the primary authorities bundle. This was a decision of Mr. Justice Ferris under Section 3031 of the 1986 Act. This was not a challenge to a disposition, but rather a challenge to the office holder's fees. Can I briefly take you to the relevant passages, and first to go to page 107 and to read paragraph 14. The judge then refers to Dodwell at paragraphs 15 to 17, which we can skip. Can we then pick it back up at paragraph 18? And can I ask you to read paragraphs 18 to 20 on page 108? The bankrupt was able to show an interest in the level of the trustee's remuneration and expenses, since paying those fees was a condition precedent to obtaining an annulment. The bankrupt's interest in applying for an annulment is self-evidently an interest which arises by virtue of being the bankrupt. It's entirely in line with the older authorities on a bankrupt standing in respect of annulment before the 1869 Act, albeit they were not cited to Mr. Justice Ferris. There's nothing in this judgment to support the proposition that the bankrupt could rely on rights or interests held in some other capacity to justify invoking the insolvency jurisdiction. Dodwell and...
You say that one can't just look at the first sentence of paragraph 19. It's not that open-ended.
Yes, my lady, absolutely indeed. What you've got to look at is the relief sought, as Lord Millett encourages us to do in Deloitte. Now, Dodwell and Engel are the only two domestic cases directly on point, which is why I've spent some time on them. Paragraphs 28 to 68 of his written case, my learned friend cites 10 additional authorities in support of his central proposition that a bankrupt has standing whenever a trustee wrongfully interferes with an existing right, regardless of whether or not that right is held in the bankrupt's capacity as bankrupt. Of these, in fact, only 2 involve applications by bankrupts. Let me address each of them briefly in turn. The first case is Schlossberg. For your note, this is discussed in my learned friend's written case at paragraphs 57 to 60. And the first instance decision you will find in supplemental authorities, page 277. I'm afraid in error, we have not included the Court of Appeals decision, which has neutral citation 2016 EWCA Civ 1138. And the judgments of both Mr. Justice Arnold, as he then was, and the Court of Appeal are reported at 2017 Chancery 210. We can provide an electronic copy of this report after today's hearing, if that would be of assistance. This case involved an application by a bankrupt within the bankruptcy proceedings to determine whether privilege over documents remained with the bankrupt or had transferred to the trustee in bankruptcy. As my learned friend fairly points out, no standing point was taken in that case, but we would accept that the bankrupt would have standing in that sort of case. The bankrupt plainly has an interest as bankrupt whenever there is an argument about whether an asset or some other interest has vested in the bankruptcy estate or remains with the bankrupt after bankruptcy. It is no different conceptually to other cases where there's a dispute about the scope of the vesting order under Section 283 of the 1986 Act, or where the bankrupt claims that property has revested under Section 283A, as was alleged in this case, or indeed where there's a dispute over a claim to after-acquired property, which we address at paragraph 55, subpara 3 of our written case.
So if there's a dispute about whether something was a tool of the bankrupt's trade,
Yes,
you would accept that that was sufficiently internal.
most certainly. In all these cases, the dispute is between the bankrupt, qua bankrupt, and the trustee in bankruptcy, qua trustee in bankruptcy. And so that dispute is internal to the bankruptcy. The second case is Lynch, which my learned friend discusses at paragraph 61 to 67 of his written case, and it is to be found in primary authorities at page 139. This concerned an application by a bankrupt under Section 303 to require his trustee to defend possession proceedings. My learned friend relies on the fact that the judge indicated he would be prepared to expedite the bankrupt's application, but given that no point on standing was being taken, that remark about case management is of limited value for the purposes of this appeal. The court, we submit, is not assisted by a submission about the dog which did not bark. Only cases where a standing point is taken are of any real value to identifying the relevant principle. Of more relevance to this appeal are the general observations made by the judge in Lynch about the scope of the Section 303 jurisdiction. This question of scope arose because at first instance, the registrar effectively transferred the possession proceedings into the Section 303 proceedings so that the issues could be determined together. The judge reversed that decision. Can I ask you to read paragraphs 39 and 40 at pages 154 and 155, 154 and 155, paragraphs 39 and 40, and that includes the lengthy quotation from the Ariel decision of Mr. Justice Mann. This distinction, which both Mr. Justice Mann and Mr. Justice Marcus Smith draw, is between rights within the bankruptcy, which fall into the Section 303 jurisdiction, and rights arising outside of the bankruptcy, which do not. In particular, it's worth noting the example Mr. Justice Mann gives in Ariel of trespass. Trespass to land is, of course, the tort which is committed when one interferes with another's possessory right to that land. As Mr. Justice Mann rightly says here, that sort of dispute should not be brought within the framework of Section 303. And this analysis clearly supports the distinction we have drawn in our case between the internal and the external. And it directly contradicts my learned friend's submission that any existing right will do to invoke the Section 303 jurisdiction, regardless of whether the right is internal to the bankruptcy. In this case, the Brakes' possessory interest in the cottage has nothing to do with their status as former bankrupts. That possessory interest in the cottage is a right arising independently and outside of bankruptcy from the Brakes' adverse possession and is vindicated through a claim in trespass. On any view, the Brakes do not have an interest in the relief they seek in their capacity as bankrupts. It follows they do not have a legitimate interest for the purposes of Section 303. Chedington's case is in line with the approach on the standing of creditors in liquidations, as well as the position taken in other common law jurisdictions. And this is my third and final submission. We've set out the authorities in some detail at paragraphs 38 to 48 and Appendix 2 of our written case. That includes 7 Commonwealth authorities dealing with the standing of bankrupts under essentially the same statutory provisions as in English law, all of which support Chedington's case on this appeal, because they refuse standing where the bankrupts cannot point to some right or interest they hold as bankrupts to which the relief relates. In the time remaining, I want to bring out one theme from those authorities, and this is the point that it is not enough to have technical capacity for standing purposes. The court must put substance over form and look at the real nature of the interest being advanced by the relief sought. The question is whether the interest being advanced by the applicant is an interest he or she has standing to advance. I've already taken you to Locke and Stanley, which makes that point in the liquidation context. Can I briefly refer you to 5 other cases, 2 of which are English liquidation cases, and 3 of which are Commonwealth authorities. First, Mohammed and Morris at page 161 of the primary authorities bundle. There, the applicants held 2 capacities. First, as creditors of the company, and second, by being subrogated to rights against the company. Can I ask you to go to page 180 and to read on that page the first 2 sentences of paragraph 26, which is at the top of the page, so going down to line 5 of that page.
Sorry, just give me the page again.
Page 180, my lord. Paragraph 26, just down to below letter A. And then if you...
This is the famous Lord Justice Peter Gibson's observation on Hans Place.
It is, my lord.
Yes.
And then if I could ask...
Section 1685, what's that?
That's the equivalent in the liquidation context.
Oh, yes.
Standing provision in the liquidation context. And then if I could ask you to read the first 5 lines of paragraph 27, ending with the words outside the liquidation. And you will then see from the first sentence of paragraph 28 that the Mohammeds are then characterized as outsiders to the liquidation. Second case is Walker Morris against Kalachi, which is in this same bundle at page 213. Here, the applicants were creditors, but their interests were adverse to the interests of creditors as they were seeking to block the liquidators' access to their records. And if you could go to the foot of page 219, in the last 5 lines of page 219, you will see that the deputy judge cites the relevant part of Deloitte, and that goes right the way down page 220. And if I could ask you to read at the top of 221, the first 4 lines of that letter A.
Starting in my view.
Exactly, my lady, yes. The third case, moving to the Commonwealth authorities, can we go...
What do you say about the second sentence? There's no absolute rule to when the court will act, and the court might well act to restrain reasonably anticipated impropriety, even if revealed by an unmeritorious application on the part of a person without a legitimate...
We say the learned deputy judge, with respect, is wrong about that. So, third, moving to the Commonwealth authorities, can we go to the supplemental authorities bundle at page 480? This is a decision of the Ontario Superior Court of Justice, where 4 defendants challenged the trustee in bankruptcy's decision to assign claims back to the bankrupt. 2 of those defendants, Global and BCI, were also creditors in the bankruptcy. And if you could go to page 484, can I ask you to read paragraphs 19 to 25, which runs over to the top of the next page, 485.
Paragraphs again.
Paragraphs 19 to 25, my lord, under the heading Global and BCI.
484.
On page 484.
down to where?
Down to the end of the paragraph, just before the word conclusion.
Oh, yes, the 25, yeah.
And I emphasise in particular the point at paragraph 22 that if an applicant asserts standing in one capacity, the burden is on the applicant to show material loss or prejudice in the same capacity. Fourth, can we go back to page 460, where you will find the Hong Kong decision. Where a bankrupt was held not to have standing to challenge his trustee's decision to respect a living will arrangement. And if you could go to page 464, you will see at paragraph 41 the wording of the bankruptcy ordinance. And at paragraph 43, a reference to Dodwell. And then at paragraph 45 on page 465, the judge notes that the evidence before her did not suggest there would be a surplus. And then can I ask you to read at paragraph 45?
I'm not sure I quite understand what a family living trust is. Will I find out if I read backwards into the judgment?
My Lord,
Or is it
yes.
something you need to know about Hong Kong law for?
No, I don't think so, my Lord. What I would ask, what I emphasise in particular, from paragraph 45, the need for the bankrupt to show an interest in the bankruptcy.
What were they trying to do? What was this case about?
He was trying to, in paragraph 17, on page 462.
Some sort of reverse decision of the family trust.
It was to do with a living will arrangement. And the trust, yes, the trustee had decided to respect that arrangement, and the bankrupt was seeking to challenge that decision.
I see the bankrupt appeared in person in this case.
My Lord, that's right.
On the face of it, it looks as if it was the assertion of an interest hostile to the interests of the estate.
That's right.
Yes.
Fifth and finally, I would ask you to turn to the case of Re Fairfield Century, which is in the primary authorities at page 235. This was a decision of the BVI Court of Appeal. It concerned an application by creditors.
I'm awfully sorry. Which bundle are we in?
Sorry, we're back in the,
the primary
authorities,
Thank
my
you,
Lord.
sorry. Yeah.
Page 235.
Yeah. This is the BVI case.
BVI Court of Appeal.
It's Eastern Caribbean.
Oh, yes, you're quite right, my Lord, it is, yes. And it concerned an application by creditors to stop the company in liquidation pursuing claims against them. And if I could ask you to go to page 256, at paragraph 32 on page 256, you will see that the court holds that technical capacity is not good enough. And I quote, if the relief is not sought in that capacity, but in some other. That, of course, is precisely the position on this appeal. The Brakes may have technical capacity as bankrupts, but the relief is not sought in that capacity. Rather, it is sought in a different capacity as adverse possessors of the cottage.
So how does the standing requirement work for any other person?
They have to show a legitimate interest within the bankruptcy.
Well, everyone has to do that.
Yes. And Woodbridge is an example of that. That is a case where the bankrupt's wife sought relief because she'd paid off the bankrupt's debts and was interested in restricting the fees and remuneration of the trustee. And she was held to have, by Registrar Baster, Chief Registrar Baster, to have standing.
Isn't the landlord, the lessor,
Yes,
the best example of that?
It is, my lord, yes. Yes.
Woodbridge is quite a generous decision, perhaps.
My lord, I would respectfully agree. But one can see why it was decided in the way it was.
All these different words, a legitimate interest, an economic interest, a recognised interest, not just a technical interest, are they all the same thing?
My lady,
in your
yes.
submission?
They are. In my submission, they are. And I respectfully adopt the Deloitte test, which refers to legitimate interest.
how do you,
I'm sorry.
how do you fit the Hans Place landlord example into your test? Because on the face of it, the landlord only gets in under any other person. He's not, at any rate, unless you go down the rather artificial contingent creditor route, which, with respect, I have some doubts about. So he's in any other person. His interest may well be hostile to that of the insolvent or bankrupt estate, because he doesn't want the lease to be disclaimed, whereas the trustee does. And his right as a landlord originates miles and miles outside the bankruptcy or insolvency.
My lord, I've heard my lord's doubt as to whether I was essentially going to adopt the explanation given by the late Mr. Gabriel Moss in his submissions in Fairfield, which was that the landlord was a contingent creditor. That was going to be my submission. I know that you've just expressed some doubt about that, but may I reflect and come back to it in reply?
I mean, the disclaimer only arises in a bankruptcy or liquidation. It is a product, a child of the insolvency process. Isn't that the real reason?
My lord, it is. And in fact, you've reminded me.
It's not a right arising under the lease that the lessor is asserting. It's a right to be heard in respect of a destruction, really, of his interest arising exclusively under the insolvency legislation.
My lord, I would respectfully agree. And could I just refer you also to the way that the Court of Appeal Lady Justice Asplin dealt with this in the Court of Appeal. And if I could ask you to go to key documents bundle, page 140.
I'm so sorry, which bundle are we on?
This is the key documents,
Key documents,
bundle, page 140.
Yeah,
Lady Justice Asplin refers to Hans Place
yes.
at paragraph 81. If I could ask you to read paragraphs 81 and 82.
Yes, it's the last three sentences of paragraph 82 which are really making the point that my Lord Richards made.
My lady, yes.
Yes. And of course, unless they can get in under section 303 or the insolvency equivalent, there's no other way they can, it's the only way in.
Precisely, my lord, and that is my last submission was to take you to page 15 in this same bundle, where you'll find the first page of our written case, where page 15 we say, paragraph 2, the single ground of appeal is bankrupts cannot have standing to interfere in the conduct of their bankruptcies where the relief sought would have no impact on their position within the bankruptcy, and or where other relief is available to them in the general law. And that, we say, would apply to...
Well, that appears to propose a quite different exclusionary test, namely you can't go into bankruptcy if you've got another route, rather than saying that there may be an additional ground of standing where the section 303 route is your only way to get in front of a judge.
Yes, yeah, I'd prefer to put it that way with respect. So, unless I...
In the Court of Appeal, Mr. Sutcliffe, there was another limb to the brakes argument, is this right? That they were claiming that as trustees of the trust and unsuccessful purchasers, they had a sufficient interest. And that failed, and it hasn't been pursued here.
That is correct, my lord.
Do you say that the reasons why that failed in the Court of Appeal also should have led to the conclusion that the claim here should have failed, and there's an inconsistency in the reasoning? Or is that too short a point?
Well, I say that the reasons why they failed in relation to the trust point, they should also have failed, probably because of...
I mean, the essential reasoning was that that their claim as trustees wasn't a claim qua bankrupt, isn't it?
That's right. Here...
Or otherwise, a claim within the bankruptcy, to use your expression.
That's right, my lord. But in that, I do say that they should also have dismissed this limb on which this appeal is based. Unless I can be of further assistance, there's a submission.
The question I was going to ask you,
I'm sorry,
was no, not at all. Was this expression taken from Lord Millett about having no legitimate interest in the relief? Is this somehow different from saying that the bankrupt is applying in his or her capacity as bankrupt rather than in some other capacity, not capacity, but interest, is pursuing an interest as a bankrupt? And you say here the breaks are pursuing interests which don't arise in any way from the bankruptcy. Are they different tests or two ways of saying the same thing?
I think you're probably right, my lord. They are two ways of saying the same thing.
Because in the Deloitte's case, one can see why it is a very powerful expression in the context of someone who is a defendant in proceedings being brought by the liquidator, wants the liquidator removed. And to say, well, they have no legitimate interest in removing the liquidator has a very clear resonance in that case. But I find it just slightly obfuscates the issue, perhaps, in the generality of cases of which I'm treating this as one.
Oh, yes, I can see that. And of course, in the Deloitte case, they were not, I don't believe they were creditors.
Yes, I was trying to remember whether they were. I can't remember. Anyway,
they were just outsiders.
I mean, it does have the virtue of doing what you took us to, which is you look at the prayer rather than all the allegations which may be expressed as, I think in one of the cases, was talking about, which are sometimes expressed in expansive terms if one looks at all those things, but then the focus is on actually the relief. That may be helpful in narrowing down the scale of the inquiry that one has to do when analysing standing.
My lady, I respectfully agree. Of course, one has to take the facts alleged as true for this purpose, for standing purpose.
Yes.
But Mr. Swift's, in fairness to him, his witness statement justifying his decision is in this same key documents bundle.
Well, I raise that only because in paragraph 85, of the Court of Appeal's judgment, which seems to be the key passage of the reasoning, it refers to it being arguable that at least some of the acts satisfy the substantive perversity test expounded in Eden Note and the Muhammad cases. Whereas I understood your submissions, which I think are supported if one focuses on relief, as saying that one doesn't get to that stage of looking whether it was perverse or not, and that can't be a factor which influences the existence or otherwise of standing.
My lady, precisely, and indeed we covered this in our written case at paragraph 61, subparagraph 3, where we say that a preliminary view of the merits has never been part of the standing test under section 303(1). The Deloitte test instead required a focus on the break's interest in the relief sought.
That's paragraph 60.
61, subparagraph 3.
Thank you.
Can I just take you back to the original progenitor of what's now section 303 in section 20 of the the 1869 Act on page 10 of the
primary
authorities bundle. The bankrupt, comma, or any creditor, comma, debtor, comma, or other person aggrieved by any act of the trustee, comma, seems as just coming at it for the very first time without having read the excellent textbook to which you referred us, to suggest that the words aggrieved by any act of the trustee are simply designed to constrain the otherwise completely general width of the phrase "or other person."
I'd agree with the way you might construe it, but actually that's not.
That's not how it works under the.
It's not how it works. It's not how the previous cases viewed it, and indeed the subsequent cases.
But it makes it difficult to say that one can build in all the standing restrictions, even if you are a creditor, within the concept of being aggrieved by any act of the trustee.
Yes.
Although if they're not, one assumes they wouldn't be there in the first place.
No, that's right, my lord. Interesting, if you look at page 13,
presumably a
The
bankrupt.
comma has been moved
Yes.
in section 90 and I haven't looked at the 1914.
Yes, they put a comma in after any other person, haven't they?
Yes, and they did in section 80 of the 1914 Act.
Very subtle way of possibly changing the meaning, if that's what.
Yes.
But it all concerns acts complained of. So the bankrupt or creditor or debtor themselves must be complaining
Yes.
of an act and therefore must be aggrieved.
Yes.
Yes. Yes.
Yes, I think.
Well, I don't know. I mean, people complain about all sorts of things, but it seems to me that your case is that aggrieved has a very special meaning, as discussed in Deloitte and all the other cases that you've taken us to, and that it meant that in section 20 just as it means it, whatever the word is now.
Well, but the word is dissatisfied.
Dissatisfied.
And it's been construed in the same way.
Yes. As my Lord Briggs said, they weren't aggrieved or dissatisfied. They wouldn't be troubling the court at all.
Yeah.
They're obviously
No.
upset about something,
Yes.
and the question is whether what they're upset about gives them standing to.
Right.
Could I just, in response to this,
It's the same point with the trust, with the bankrupt, you would say. It's what they're aggrieved about which determines whether they have standing.
Exactly, my lord. I think what Mr. Justice Ferris says in Engel is also of assistance here, and that's at paragraph 14 on page 107 of the primary authorities. In particular, the second half of that paragraph. We respectfully.
Although you're not happy with what he then goes on to say, if he can show he has some substantial interests which have been adversely affected. I mean, you presumably say that's much too wide.
Yes. Yeah, we say that's limited by capacity and it's too wide in the sense that it's there. State.
Yeah, thank you. Well, we've taken you slightly over your time, but it wasn't your fault, Mr. Sutton.
Thank you. Thank you.
Entirely ours.
Thank you.
Yes, Mr. Curl.
Thank you, my lord. My lords, my ladies, reduced to a sentence, the Brakes case in answer to this appeal is that we have the necessary interest, call it legitimate interest, call it substantial interest, that has been adversely affected by an act, omission or decision of the trustee in bankruptcy. And there is, in our submission, no support in the case law for the external-internal distinction that my learned friend draws. It is unduly prescriptive and an unnecessary gloss on what the cases in fact say. I should like to take my submissions in 4 sections. I'd like to address firstly, briefly, the factual chronology, because it isn't straightforward, and in my submissions it is important to understand exactly when things happened. Secondly, I should like to address why this application really matters, what is actually in issue. In particular, what are the economic rights that are affected by the outcome of this application. Now, thirdly, I would like to summarise the matters that are complained of, and this is not inviting the court to take a preliminary view of the merits. It's simply to demonstrate the nature of what was done by the trustee in bankruptcy in that capacity, expressly as trustee in bankruptcy, to the Brakes expressly in their capacity as bankrupts. And focusing on the nature of the interest that the Brakes are said not to have, i.e. there is no surplus here, is to obscure the real issue, which is that these are things the trustee did qua trustee to the Brakes qua bankrupts. And that illuminates a point that I'll develop, which is that this isn't a Dodwell category disposition case, as my learned friend sought to characterise it. Fourthly and finally, I will then turn to the legal position and what the authorities say. So taking first the facts. In 2004, Mrs. Brake purchased West Axnoller Farm, which is the house with surrounding land. And I'll refer to this as the house, because the position of the house will be important when I come on to the second section, which is why this really matters.
Mrs. Brake, did you say?
Yes,
Brake.
Mrs. Brake.
Mrs. Brake, that's what I thought you said, yes.
In February 2010, a partnership agreement in relation to a partnership called Stay in Style was put in place between the Brakes, Mr. and Mrs. Brake, and Patley Wood Farm LLP, which was a LLP controlled by Mrs. Breen. Later in 2010, the cottage was purchased and registered in the joint names of Mrs. Brake, Mr. Brake, and Mrs. Breen. Subsequently, the house and surrounding land was used as a wedding and events venue, and the Brakes stayed in the house primarily.
When you say the surrounding land, are you talking about the adjacent land there, or just the farm?
No, yes, the latter, my lady. The adjoining land is separate, and that is related to the cottage. When I refer to the surrounding land, I mean the estate connected with the house. So the Brakes stayed in the house primarily, but also stayed in the cottage when it was let to paying guests. When the house was let to paying guests, I should say. Sometime after 2012, there was a partnership dispute that was referred to arbitration. PWF, the LLP of Mrs. Breen, was the successful party in that arbitration, and a large costs award was made against the Brakes. In October 2014, the mortgagee of the house appointed receivers to sell the house. It was then sold to Axnoller Events Limited, and the cottage was unaffected by that, as the mortgagee did not have a charge over the cottage. In May 2015, the Brakes were adjudged bankrupt on PWF's petition in relation to the arbitration costs. In July 2016, the Stay in Style partnership went into administration, and it subsequently went into liquidation in May 2017. In February 2017, Chedington, which is the appellant today and is a company owned by Dr. Guy, acquired the shares in Axnoller Events Limited, which carried with it the ownership of the house.
Sorry. Is that right? I'm sorry, I'm getting a bit lost. I thought you said the house had been sold.
Yes, the house was sold in 2014 to Axnoller Events Limited.
Oh, I see. Sorry. Yes.
No, not
Thank
at
you.
all.
Thank you.
So, yes, in February 2017, Chedington acquires the shares in Axnoller.
Yes, I'm with you.
And at this time, February 2017, which I invite the court to note was nearly 2 years after the bankruptcy orders had been made, the Brakes entered into employment contracts with the Guy parties. So it is nearly 2 years after the bankruptcies that Dr. Guy first comes on the scene. In November 2018, following a falling out between Dr. Guy and the Brakes were dismissed from their employment. And this is when the bilateral dispute between the Brakes and the Guy parties commenced, more than 2 years after the bankruptcy orders were made. In November 2018, Axnoller Events Limited commenced possession proceedings in relation to the house. In December 2018, bids were made by both the Guy parties and the Brakes to the partnership liquidators to acquire the cottage. On 10th of January 2019, the facilitation agreement was entered into between Mr. Swift's firm and Dr. and Mrs. Guy. We'll come on to that document in quite a bit more detail.
I'm not sure I got your note about what you said happened in December 18.
Yes, in December 2018, there was a bidding process run by the liquidators of the partnership in relation to the partnership's interest in the cottage. And both the Guy parties and the Brakes made bids at that time.
Thank you.
And the Guy bid was regarded as the successful bid, although the cottage was sold by the liquidators, in fact, to Mr. Swift in circumstances that we'll come on to. So 10th of January 2019, the facilitation agreement between Mr. Swift's firm and Dr. and Mrs. Guy. And then on 15th of January 2019, following the arrangements that had been put in place under the facilitation agreement, there were the back-to-back sale agreements entered into. Namely, the liquidators sold their interest in the cottage to Mr. Swift, and Mr. Swift then entered into a subsequent on-sale to Chedington in relation to the interests that he had acquired in the cottage and the interests that the estate already had. On 17th of January 2019, so almost immediately after the back-to-back sale agreements, there was a hearing in Yeovil County Court in the house possession proceedings. And at that hearing, counsel for Axnola Events Limited, i.e. the claimants in the house possession proceedings, told the court, if we are the owner of the cottage, we will permit the Brakes to occupy the cottage during the weddings being the events that were run at the house. And as a consequence of that, the Brakes gave undertakings to the court that they would permit weddings to be conducted at the house and would leave for the cottage during those times. The following day, despite what had been said at court, the following day, the eviction, which has now been found by the Court of Appeal to have been unlawful, was carried out by Chedington, evicting the Brakes from the cottage. On the 12th of February 2019, the Brakes issued the bankruptcy application that is now before this court today. On the 3rd of April 2019, the Brakes, as well as their son Tom, issued the cottage eviction proceedings against Chedington, and it's that claim that has recently been determined in the Brakes' favour by the Court of Appeal. It was only on 10th of April 2019 that Chedington was added as a respondent to the bankruptcy application that's before the court today, although of course Chedington is in fact the only active party against the Brakes on that application. On the 6th of June 2019, Mr. Swift was removed as trustee of the Brakes estates by consent, and new trustees were appointed. And on 3rd of March 2020, the bankruptcy application was struck out by His Honour Judge Matthews, and on the 13th of November 2020, the Court of Appeal reversed Judge Matthews' decision in relation to the bankruptcy application, and it's the appeal from that decision that's before your lordships today. So, having introduced the chronology in that way, I should now like to move on to the second aspect of my submissions, which is why the outcome of this application really matters and what interests are really at stake here. Now, the substantial interest that the Brakes assert as a sufficient interest to enable them to invoke section 303(1) was their existing possessory right to the cottage. Now, that right was, on the Brakes pleaded case, unlawfully interfered with by the trustee in bankruptcy with a view to assisting Chedington, a stranger to the estates, in its dispute with the Brakes. So this wasn't day-to-day conduct by the trustee in bankruptcy. This wasn't ordinary disposition of assets. This was an unlawful interference by the trustee in bankruptcy done for the purpose, which we say was an improper purpose, of assisting Chedington.
Is Chedington a creditor in the bankruptcy at all?
My understanding is it is not. I stand to be corrected if that's not right. Mr. Day nods his head. I'm obliged.
So you say that what takes this out of being the kind of everyday conduct which the courts are clear that a bankrupt cannot challenge is what exactly?
The trustee in bankruptcy here acted beyond his powers, we say. He acted for improper purposes. And what the improper purpose for which he acted was precisely in order to do down the brakes. It was to give assistance to Chedington in a bilateral dispute between Chedington and the brakes. And that appears to have been done.
What was the nature of that dispute?
There were a number of disputes, as I understand it. There was an employment dispute because the brakes had formerly been employed by Guy entities in relation to running this weddings and events business. I'll need to take instructions on that aspect.
No, I'm just getting a general.
But Chedington was the conditional purchaser of the cottage.
Yes.
From the trustee.
That's right.
And therefore was a person with whom the trustees were dealing under a contractual arrangement. Trustee was dealing under a contractual arrangement designed to lead to the cottage being sold outright to Chedington.
Yes. Yes, my lord.
So it was Chedington may not have been a creditor in bankruptcy, but it was someone in a contractual relationship with the trustee. And you're not, at this point in time, criticising the facilitation agreement, as I understand.
No, we are.
Well,
we are.
That's why I'm asking, because you said thus far the eviction was out with the trustee's powers as being something for an improper purpose designed to help Chedington. But one has to see the eviction in the context of the facilitation agreement, does one not?
But absolutely, my lord, yes. The contractual arrangements, my lord, are really the vice here. The contractual arrangements, we say, were entered into between the trustee and Chedington precisely for the purpose of doing down the brakes, getting them out of the cottage and assisting Chedington in its bilateral dispute with the brakes. So, my lord, the facilitation agreement is quite stark, in fact, in its terms, and I will take the court to that shortly. The facilitation agreement predated the back-to-back sale contracts and the licence, and it is the facilitation agreement that really sheds light on what the trustee in bankruptcy's purposes were in entering into these arrangements. And we say, in answer to my Lady Rose's point a few moments ago, is that we say the purpose that actuated the trustee was an improper purpose that was targeted at the brakes in an improper way that did not fall within his powers or functions as a trustee.
But it isn't the problem with that that if you say a bankrupt's application is not to be regarded as challenging the everyday, day-to-day conduct of the trustee, if the bankrupt alleges that what was done was for an improper purpose or beyond the powers of the trustee, doesn't that then open up the possibility of very many applications where the bankrupt will have standing, assuming that in order to determine standing, you have to assume that whatever is alleged by the bankrupt is true for this purpose. So then every time they allege that what appears to be a legitimate piece of conduct, transaction, is improperly motivated, that then it's outside everyday conduct and therefore the bankrupt has some interest in challenging it. Can that be the test?
Yes, my lady, the concern of giving a green light to bankrupts to bring applications is a very real one, and I'm certainly not inviting the court to relax the test for standing such that bankrupts would be able to bring those kinds of applications. That is a very real concern, and I fully acknowledge it. And it's not our case that the test for standing should be relaxed.
Well, what was the Brakes' possessory right to the cottage? I struggle a bit with that. They were living in the house, weren't they?
Yes, they were living in the house. Well, they were living between the house and the cottage, depending on when the events were running. So when there was an event running, they resided at the cottage.
Right.
Well, they had a corpus possessionis, didn't they, in the form of various bits and pieces of furniture and
Yes.
assets of
Yes, and
theirs
there were clothes
that
kept
was
there and so on.
either stored or at any rate in the cottage.
Yes, that's right. Yes. Yes, the Court of Appeal has found that they were in possession of the property and they were unlawfully put out of it. If I could...
Suppose somebody else had been in that position in the property, the tenant of theirs, what would the position be then?
If the trustee in bankruptcy had entered into contractual arrangements with the specific purpose of targeting those tenants in order to do them down in a bilateral dispute with a third party, and he had used his powers, or purported to use his powers as trustee in bankruptcy in order to do that, then they would have standing to apply as well, my lord. If I could return and address my lady.
As any other person agreed, do you mean?
Yes, that's right, my lady, yes. To return to your ladyship's point, the facts that are alleged do assume, have to be assumed to be true. That does not necessarily of itself mean that a bankrupt will have standing to apply under section 303(1). The facts that are alleged have to be of a sufficient nature in order to disclose a sufficient interest, a legitimate interest, that has been adversely affected by the trustee in bankruptcy. The section 303 of the Insolvency Act is about regulating the conduct of trustees in bankruptcy, and there are certain things that trustees in bankruptcy can't do, and they are not permitted to act beyond their powers, and they're not permitted to act for improper purposes. The thing that separates this case from the general run of cases that bankrupts would want to pursue, which, as I acknowledged a few moments ago, are very often going to be without merit, and they're not going to be things that the court would want to encourage. But what separates the instant case from that general run of cases is that the bankrupts had an existing interest that was interfered with, and that was their possessory right in the cottage. And the economic implications of that are something that I will develop as I move forward with this submission.
Isn't the bankrupt's estate as vested in the trustee often, if not usually, going to include the house where the bankrupts are living?
Precisely so, my lady. And the law is that trustees in bankruptcy cannot evict bankrupts from their family homes without a court order. So what they can't do is enter into arrangements such of the nature that we find in this case, which are created with a view to getting people out without a court order in the way that it was done in this case. That sort of conduct, evicting people without a court order, is precisely the sort of thing that trustees in bankruptcy shouldn't do, because they get a diet of work in the county court of granting eviction orders to trustees in bankruptcy day in, day out. It's very common form of application.
But the requirement for a court order in that context isn't something in the bankruptcy legislation, that's just in the Protection from Eviction Act, isn't it?
Yes.
It depends upon the evictees being resident. I mean, you ran a case, as I understand it, under the Act and lost because you weren't resident, you were merely in possession. You weren't in occupation, you were just in possession.
Yes, I didn't act in that.
No, the breaks, your clients.
Yes. Yes, there is machinery in the Insolvency Act that restricts what trustees in bankruptcy can do when applying under the general law for possession of bankrupt homes, Section 335 and Section 335A of the Insolvency Act do put in place additional protections for bankrupts in relation to their family homes. So
But that's not our case.
that's not our case, my lord. No, but it's directed at the observation from my Lady Lady Rose that it is commonplace for bankrupts to be in possession of assets that are vested in bankruptcy estate. Mr. Colclough points out to me that it's 1 o'clock precisely.
Yes.
I wonder if that's a convenient moment.
We'll resume at 2 o'clock.